Okay, let's get today's party started here. I want to thank everybody for joining us for today's presentation. This is In the Weeds, Marijuana and Workplace Drug Policies. My name is Nick Hartman, co-founder and managing partner of the Drug Screening Compliance Institute, DSCI. Today's event is proudly presented by 210's Human Resources Leadership Group. And with that, I would like to welcome Jeff Green, Vice President of Talent Acquisition, to our conversation. Jeff?
Thanks a lot, Nick. On behalf of the HR Leadership Group for 210, I want to welcome everyone to our second webinar, and more to come. We're looking at doing a webinar every single quarter. We represent 210. For those that do not know, 210's mission is to improve the lives and careers of footwear employees and their families. And they do it through different ways. They provide financial assistance, disaster relief. They provide counseling services along with scholarships. And I'm sure I'm not doing the organization justice by just mentioning those few things. But anyway, they're an integral part in the footwear industry, and as far as I know, there is no other organization like that in any other industry. So for those that are not familiar with 210, their website is TWOTEN.org. Please connect with them. If you have more questions, you guys can communicate with me. I'm easy to find on LinkedIn. I'm Jeff Green, and Jeff is with a G, G-E-O-F-F. And green is just like the color. So thank you very much, Nick, for giving me a minute, my 1 minute of fame, and I'll turn it back over to you.
Yeah, thanks, Jeff. Sounds like an awesome resource for everybody out there. So as a quick housekeeping item and a reminder for everybody's going to be muted during this presentation. However, we certainly welcome you to submit any questions that you might have. There's a Zoom chat feature at the bottom of the Zoom platform. So if you have a question throughout the presentation, feel free to submit your chat. We've reserved some time at the end of today's presentation to address any questions you might have. This event does qualify for a professional development credit for your SHRM recertification. The code will be available for all attendees that stick around to the conclusion of the presentation today. And also, everybody will receive a copy of today's recorded presentation just in the days following today's event. Real brief, Drug Screening Compliance Institute assists employers, industry professionals, insurance providers, risk managers, lawyers, and other service providers with workplace drug and alcohol screening compliance, policy development review, procedures, risk mitigation, education, training, and general consulting. Bill and I and our team spend our days reviewing the hundreds of state-specific laws and thousands of court cases on this topic, along with agency decisions, legal changes, researching issue specifics, and documenting all the compliance requirements for workplace screening in our industry here. Of course, our goal is to take the complexity out of the growing cobweb of compliance for all of our clients. Our team is standing by to assist you with understanding and staying compliant with state and federal workplace drug screening laws. We're more than happy to review, revise, or develop your drug-free workplace policy, procedures, and now more important than ever, job descriptions. We also provide training, education, litigation support, and general compliance consulting. We invite you to visit www.askbilljudge.com and sign up for our complimentary industry compliance alerts that'll keep you in the know as the legal landscape changes. I have the pleasure of introducing today's presenter, my colleague, William Judge. Bill is an attorney with more than 33 years of experience in the workplace drug screening industry. He's my fellow co-founder here at DSCI and has long been recognized as an industry thought leader, regularly presenting at local and national events. Quick legal note before we get started. While Bill is an attorney, the DSCI is not a law firm. The information being presented today is for general information purposes only and should not constitute as legal advice. I got it out of the way, Bill. So without further ado, I'll turn it over to Bill Judge.
Thank you. Thank you very much, Nick. I appreciate that. Nick, by the way, has many years of experience in establishing and running employer programs for drug testing. So he also has tremendous experience in this world of drug and alcohol testing. But enough of the commercials. Let's get on to the information. What we're going to try and do here today is provide you with an overview of the marijuana laws that can impact your job, your workplaces. We're going to focus on things that you can and can't do as it relates to these laws. We're going to focus a little bit on anti-discrimination laws and as well as key court cases and some mandatory rules as well. We're also going to try and set up some time here so that you can ask your questions, and please don't hesitate to ask questions. It's very important. We go through this stuff all the time, so but we want to make sure we understand what it is on your mind and what you're worried about. So please ask your questions. We come from a position of believing that information is key to protecting you. And now when I say protecting you, I'm not just saying about losing cash, although employers are increasingly losing lots and lots of money because they just don't know the rules. And I'm talking about you personally. I don't want to see any one of you serve as a defendant in a lawsuit. There's no need for it. If you know the rules, you should be able to avoid some of the litigation that's flying around out there right now. And I'll tell you what, Nick and I can tell you, because we read this stuff every day, all day long. Lawsuits are increasing dramatically on these issues. So please get the right information, whether you get it from us or somebody else. Just get the right information so that you know what's going on, not only at the federal level, but in your states. These states' laws differ phenomenally, and you need to know how they impact you. If you don't pay attention to these laws and these rules, you can spend a pile of money. Notice how I did that with the money piled up. Nick and I keep track of jury awards, judgments, consent decrees, and so forth, and track how much employers are losing by not complying with the rules that apply to these programs. And we're seeing judgments and settlements and jury awards ranging anywhere from $30,000 to over $2 million. This is starting to get real. So please pay attention to these issues. So let's jump right into it. Let's talk about medical use of marijuana, and we'll throw in some of the personal use issues as well. Starting with the federal position, where are we today? Well, we have to look at the DEA, the Department of Justice, the Department of Agriculture, so we can get a real good sense of what's happening from the federal level. And what you need to know at the beginning here is that even though we have a lot of states' laws that are authorizing medical and personal use of marijuana as well as CBD, on the federal level, marijuana is still a crime. Marijuana is what's known as a Schedule I drug, and what that means essentially is that it has a high potential for addiction, and that there is no current recognized medical use. So on the federal level, marijuana possession and use and cultivation and so forth is a crime. Okay, how does that work as far as the conflict with the state's laws? Well, we'll see that shortly as we talk about some of the key court decisions on the case. The DEA, interestingly enough, we're seeing some sort of relaxation, I would say, on the federal level of some of these issues. For instance, the DEA recently rescheduled a marijuana-based substance called Epidiolex. and it's now scheduled as a Schedule 5 drug, meaning that it has a number of medical uses. Now, the medical uses that were approved by the FDA and then rescheduled as Schedule 5 by the DEA are extremely limited. They deal primarily with epileptic seizure disorders, and the type of cannabidiol or CBD that's approved can have less than 0.1% of THC, which is the active ingredient in marijuana, which causes a psychoactive reaction. So the approved drug is extremely limited. The Agriculture Department, as of December of 2018, hemp has been removed from the definition of a controlled substance. So hemp and all of the derivative substances, including cannabidiol or CBD, are no longer considered a crime. They're no longer part of the Controlled Substances Act. But there are extreme restrictions here. We'll get into it here in a moment, but bottom line is that people who are out there buying CBD at their local gas stations or the local drugstore or even online, most likely they're buying a product that is illegal, okay, just so you know. The Department of Justice, which obviously the DEA is part of, has been restricted in terms of the funding. You may have, or we may have, an attorney general who says we're going to go full bore ahead and arrest people who are violating the Controlled Substances Act and so forth. However, what you have to understand is that Congress has limited the funds that they get, and they cannot use any funds that they've been provided under the omnibus budget bill to go after anybody who is in compliance with a state medical marijuana law. So they may say that they're going to go after folks, but they don't have any money to do it. Okay, so that's the federal situation. But on the state level, which is really what we need to talk about here today, we want to take a look at where we are. And so as of today, there are 33 states and District of Columbia and some of the U.S. territories that have authorized medical use of marijuana. Now, I say as of today because this is changing constantly. So we have to keep updating these charts and these maps so that you can see what's going on right now. But as of today, those 33 states that you see in that bluish, aquaish color permit the medical use of marijuana. Now, that doesn't mean people just run off to a doctor and get it. I mean, there's a lot of myths about how this all functions. In every single state, and yes, even including California, there are very detailed rules that have to be complied with by the doctors involved, by the individuals who want to be authorized to use medical marijuana, by the growers and the dispensaries. All of them have very strict rules that have to be complied with. Right now, we have 11 states in the country that have authorized the the personal use. If you're over 21 in these states, you can now, or soon will be, like Illinois will be January 1st of 2020, you can purchase marijuana for your own personal use. Again, there are restrictions. You have limited amounts that you can buy in each state. 18 states today have authorized the use of cannabidiol or CBD. What's the difference? Marijuana, typically known as THC, tetrahydrocannabinoid, which has the active ingredient of the cannabis plant, is what we typically refer to as marijuana. CBD is also a compound that comes from the cannabis plant. You may not be aware, but there are literally over 400 different types of compounds that come from the cannabis plant. And two of them are the most common, CBD and THC. CBD does not make you high. And as we will see, it does not cause a positive drug test. But these 18 states have authorized the use of CBD for very specific and limited medical purposes. Those three states, Missouri, Oklahoma, and Utah, that are shaded there a little bit, are in that shaded fashion because they just recently passed medical marijuana laws, and it isn't quite clear yet how their CBD laws that existed are going to exist or play with the medical marijuana laws. Are they going to be consumed by the medical marijuana law? Are they going to stand alone? We just don't know yet. So that's why we've shaded it. So as it stands today, here's what our map of the country looks like. And you can see that there are only two states, Idaho and Nebraska, that don't have some form of either personal, medical, or CBD authorization on the books. So that's how the map looks right now. Okay, and by the way, in both Idaho and Nebraska, there are efforts underway to authorize the use of medical marijuana, at least, perhaps CBD. We'll see how that all plays out. That's what the state's maps look like right now. As I mentioned, these states' laws differ completely. Very, very detailed differences here. Some states authorize marijuana and define the substance as any part of the plant marijuana. Some states say you can use it, but it's got to be used in a smokeless fashion, such as Minnesota. And of course, then some states authorize only the use of the oils or CBD. Cannabidiol, CBD. Here's a brief look at it. Will CBD get you high? No. The answer is no. Will CBD cause a positive drug test? No. Now, let me back up for a second and explain why somebody might come to you and say, my positive for marijuana was caused by CBD use. They're probably using a product that's unauthorized. Every single state that authorizes the use of CBD has very specific limitations on the amount of THC that substance can contain. Most states say that less than 0.3% of THC is permitted in the processed cannabis that's known as CBD. That is a tiny amount of THC. It will not, therefore, get you high, and certainly will not test positive. So can somebody be high from the use of CBD? Yes. Can somebody test positive from the use of CBD? Yes. But they're probably using unauthorized CBD purchased from a source that is not permitted in their states. And if it's a source that's not allowed in their states, like on the internet or at the local gas station or what have you, then nobody knows what's in it. It could very well contain a lot more THC or marijuana than is permitted by law, and so they may very well test positive. But they're using an unauthorized form of CBD. And so you need to make efforts to caution your employees to make sure they understand this. One example, for instance, is the state of Iowa authorizes the use of CBD. However, you can only get it if you've gone through the process of getting a physician's recommendation, getting a card authorized by the state of Iowa, and you can only purchase it from one of 5 state-operated dispensaries. So if you're not authorized by the state, you don't have a state authorization card, and you didn't buy it from one of the 5 dispensaries that are run by the state, you probably are using an illegal substance. So let's make sure we understand that, yes, can you test positive? Sure, but it's probably illegal, the substance that you used. I'm sure there'll be questions about that because there's a lot of confusion about what CBD can and cannot do. Okay, let's look at some specifics. Here, 14 states, as you see, indicate specifically in the statutes that employers need not accommodate marijuana use at work. They need not accommodate employee being under the influence at work. That's the key phrase, by the way, at work. The language of a lot of the states differ. Illinois, Ohio, Pennsylvania, very, very employer friendly in terms of the rules that they have in place right now. But you have to also be aware that Massachusetts, Nevada, and New York require employers to at least determine if they can medically accommodate, reasonably accommodate the underlying medical condition. So Nevada as an example. Nevada's law specifically states that employers need not accommodate medical marijuana use at work, but they must take steps to determine if they can reasonably accommodate the individual's underlying medical condition. Okay, so you don't have to allow medical marijuana used at work, but can you accommodate that individual's medical condition, which resulted in them being recommended for marijuana use. In New York, that state's medical marijuana statute specifically states that an individual who is an authorized medical marijuana user is considered disabled, and they are entitled to protection under the state's human rights law, Article 15. So what does that mean to you as an employer? Well, that means that you've got to take steps to determine if you can reasonably accommodate that person's underlying medical condition. For those of you that are in New York City or operate in New York City, be aware there is a new ordinance that takes effect, I believe it's May 20th of 2020, and it prohibits essentially denying employment on a pre-employment test for someone who tests positive for marijuana unless they're in certain safety sensitive positions. This is where, quite frankly, we are emphasizing and stressing the need for every single one of you to go back and dust off your job descriptions. You need to make certain that you have very clearly stated job descriptions and clearly indicate which positions are considered safety sensitive and why. This is going to become increasingly important as these states' laws continue to be interpreted by our courts. These states have limits on what employers can and can't do. So, for instance, in these 10 states, employers cannot discriminate against a medical marijuana patient simply because they are one. So you cannot discriminate based on someone's status as a medical marijuana patient. Employers can specifically take action in these states, either by specifically stating so in the statute or as a result of court decisions. As an example, in California, employers have been successful in defeating challenges to disciplinary action in California by medical marijuana patients. In a case decided by the California Supreme Court in 2008, an individual who was terminated brought a claim that they were protected by the state's medical marijuana law, and the court said no. you're not, because the state medical marijuana law has nothing to do with the workplace. It is a criminal defense statute and doesn't have any protections for employees who are medical marijuana patients. Similar rulings were made by the highest courts in Washington, Oregon, Montana. Oregon's interesting because they ruled in favor of an employer when an employee brought a case claiming that they were protected from discrimination in the workplace for off-duty use of legally consumed products. Marijuana is legal in Colorado. This is a very interesting case. The court ruled in favor of the employer because the court said that the product being used must be, quote, legal. And they said it's not legal on the federal level, therefore it isn't completely legal. And they ruled in the employer's favor. There are about 19 states that have these kinds of laws that protect employees from discrimination for off-duty or off-premises use of legal products. It's going to be interesting to see how the other states interpret their laws in relation to either medical marijuana or personal use of marijuana laws as well. Illinois is an interesting example. Some of you may be aware that Illinois' law was recently signed by the governor authorizing adult use, personal use of marijuana. That law takes effect on January the 1st. What's interesting about it is that at the last moment, negotiations that took place essentially added a provision 900-50, and that law it basically incorporates into the personal use of marijuana law an act that's been on the books for quite some time. That's essentially a privacy at work law, and it protects individuals from the use of products off duty that are considered legal. However, there's a section of that off-duty protection law. It's section B in the second sentence that says this law does not apply to products that could impair performance. All right. We don't know how that's going to end up getting interpreted by the courts, because one thing that I'm sure you're all aware, there is no scientific or medical way to determine right now if somebody is impaired from the use of marijuana. We don't have an alcohol type cutoff level of 0.08 for the use of marijuana. There are some states that have passed laws for DUI purposes that say if you've got more than 5 nanograms of marijuana in your system, you're considered positive and intoxicated. But as a general rule, there is no scientific way to determine if somebody's under the influence of marijuana. So we're in a bit of a dilemma as it relates to that question. Employers can specifically take action, but in these 5 states, you're allowed to take action if someone is using at work or being under the influence. However, a positive test alone in these 5 states is not considered proof of being under the influence. So what does that mean? Well, that means you're going to have to, dust off your training programs and make sure that your management, your supervisors are trained to recognize the signs and symptoms of drug and alcohol use. Because in those 5 states, even though there's a positive test, that alone will not permit you to take action against somebody who's used marijuana. In these 5 states, there are immunity statutes related to drug testing. Why is that important? Well, it can be important. Like in Arizona, there was a recent court case where the 2 statutes, the immunity statute and the medical marijuana statute, went head to head. And the court ruled in favor of an employee in the case. It involved Walmart as the employer. And Walmart said, look, we're permitted and immune from any kind of lawsuit, including for wrongful discharge, because we qualified under the Arizona drug testing statute. We abided by all the requirements on how to test and so forth, so we are entitled to immunity. Well, the Arizona statute, as you know, says that a positive test alone is not proof of being under the influence, right? Okay, so the court said, here we are, we've got these two statutes. Let me flip back and forth. One provides immunity for taking action for a positive drug test. The other says you can't use a positive test alone to show the person's under the influence, which allows you to take action. So what do? Well, the court said these two statutes are fine together. They can be, they live together. What you need in Arizona, the court said, was not just a positive test. That's a start. What you need to do is have evidence that the individual showed signs and symptoms of drug and alcohol use. Then you're entitled to immunity. All right. Well, we'll see how these other state statutes are interpreted and go from there. But very complicated stuff here. Okay, so here's some stuff hot off the presses. Well, first of all, let me tell you about New Jersey. New Jersey, just last week, the governor signed a law that amends their existing Compassionate Use Act, and essentially says that employers can take action against someone who tests positive. It essentially is a very employer-friendly statute, okay? Nick, I don't know if you've got anything to comment about that, the New Jersey law, but if you do, I'll throw it your way.
No, we're good, Bill. It's just something that people need to be aware of and ask more questions about.
Yeah, absolutely. The law in New Jersey now specifically prevents discrimination for prevents employers from taking action just because someone is a medical marijuana patient. In other words, their status. But if an employer has a policy and the individual violates that policy, employers can take action. So there are just a few items that are required of the employer. You have to give the individual an opportunity to try and explain the positive test. You have to put that in writing and hand it to them, give them notice of it. So there are a few steps that you should be aware of if you're operating in New Jersey related to the new law, okay? New York City, we already mentioned about the pre-employment limitations for marijuana testing. The Nevada law, it's the first state in the country, actually, to pass a law essentially that limits pre-employment testing. However, in Nevada, the law essentially allows the employer to identify what a safety-sensitive position is, and then you can still go ahead and do pre-employment testing. So there again, that shows why job descriptions are key. Illinois became the 11th state to authorize personal use of marijuana, and that starts January 1st. Oklahoma recently passed what they referred to as the Unity Bill, and expands medical marijuana to include safety-sensitive a little safety-sensitive carve out there, again, like some of the other states, that allows the employer to identify what positions are safety-sensitive. New Mexico amended its medical marijuana law to provide protections to employees and applicants. So if you're in New Mexico, you want to make sure you get a copy of the most recent statute amendment that took effect on April 4th. If you have questions, please jot them down and make sure we get a chance to answer them for you. Marijuana and workers' comp. This is an interesting situation here, folks, where a number of states, New Mexico started it all, have required now employers to reimburse a worker who had been injured at work for the cost of marijuana to treat their injuries or illnesses under very detailed restrictions, limitations. In these states, you have to very carefully look at the definitions of the program that's permitted. In Maine, you can see there in red, the court said no, an employer doesn't need to reimburse. The statutes in some states, those that are in that bluish aqua color, say that it's not required to reimburse. Interestingly enough, so did New Mexico's law, so be careful there. In a couple of the states, the statute says it's not required, but then the court went ahead and said they are required to reimburse the cost of marijuana to an injured worker. Those that are in the brownish color, the statute says it's not construed or even discussed at all, and as well as those that are in the dark blue. New Mexico is in its own world there with the dot shading, because it has a very specific. There were 3 court cases, in fact, that ruled employers had to reimburse, and it now has a schedule of reimbursement that was put out by the Workers' Comp Commission. So if you're in New Mexico, please be careful and make sure you understand what's required there. Okay. State disability discrimination statute. It's very important that you understand that increasingly what's going to be important for you is not necessarily the state medical marijuana statutes, but the need to accommodate somebody's underlying medical condition so that you don't violate state disability laws. One point about this, people ask all the time, well, does the ADA protect marijuana users? No, it does not. Why? Because let's remember, under federal law, marijuana remains a crime. So as a federal program, the ADA cannot authorize protection of somebody who's committing a federal crime. But state disability laws will protect or can protect those who are medical marijuana patients, not because necessarily of the marijuana use, but because of their underlying medical condition. Take as an example, one recent court decision out of Massachusetts, the state Supreme Judicial Court, I should say, in Massachusetts, ruled recently that the employer should have taken steps to accommodate a medical marijuana patient's underlying medical condition. Now, what's interesting in the case is it's the Barbudo case. And what was interesting in that case is that the court said that the employee did not have the right, the authority, to sue their employer under the marijuana statute, the medical marijuana statute. But the court said the employer should have taken steps to enter into the appropriate interactive process to determine if they could reasonably accommodate the underlying medical condition of that medical marijuana patient. In fact, what the court said was that marijuana, because it's legal in Massachusetts, should have been treated like any other prescribed medication. Now, that's a pretty extreme position. Other state courts that have ruled in favor of employees include Arizona, and we talked about that. Rhode Island, a court found in favor of an applicant because they determined that the employer refused to hire her, actually refused to allow her to even go through the process and take the drug test, but they refused to hire her based on her status as a medical marijuana patient alone. In New Jersey, a court just recently decided in favor of an employee, again, based on the employer discriminating against them based on their status. Same for Delaware and also Connecticut. Now, what's interesting about Rhode Island, New Jersey, Delaware, Massachusetts, those states specifically said the Controlled Substances Act, when it comes head-to-head against a state medical marijuana law, we're going to decide in favor of our state law. The Federal Controlled Substances Act does not preempt our state law. Very interesting approach and determination by those courts. And I will tell you, that's just the beginning. We haven't even seen court decisions in most of the other 33 plus states that have authorized the use of marijuana. So, we're only at the beginning of this, and that's why you need to find a source that you can follow so that you're staying in touch with what the changes are. All of this fits into, or must fit into, all of the complicated other issues you have to deal with. Quite frankly, from our perspective in helping employers with policies and procedures, marijuana issues are just one piece of the puzzle. We have to look at state rules that require testing in a certain way. Workers' comp issues. Are you hoping to defeat a work comp claim? Okay, well, you may have to in certain states, or want to in certain states, take advantage of certain rules that apply that allow you to defeat work comp cases a lot easier. ADA issues when it comes to prescribed medications other than marijuana. OSHA, oh my God, OSHA, don't get me started. OSHA in 2016 came out with a little rule, and we could talk about that for about a week, that essentially left employers wondering if they could do post-accident testing at all. Fortunately, in 2018, they issued an interpretation, what they called a clarification, saying, yes, employers can do post-incident, post-accident drug testing. However, one little wrinkle there, keep in mind the OSHA rule said that employers cannot just test the injured worker. Under OSHA's interpretation, employers are required to test all those who may have contributed to the accident. Okay? So please make sure your post-accident, post-incident drug testing policies accurately reflect what OSHA permits, because there are some states that are issuing fines here. You've got a lot of agency decisions, and that's where your state disability discrimination laws come into play. If you want to defeat an unemployment case, you certainly better make sure that you're in compliance with state's rules. And then, of course, there are federal rules like DOT and so forth. And let me mention that when it comes to marijuana issues in DOT, DOT has issued statements indicating that they will not accept the fact that a driver is a medical marijuana patient, or that the state that they're in allows them to use on a personal level. DOT, being a federal agency, must follow federal law when it comes to marijuana, which remains a crime. NLRB issues. Well, under the NLRB rulings, if you have union workers, please be aware that when it comes to reasonable suspicion, you must allow that worker an opportunity to confer with a union rep, and if they want to, they can have a union rep present during the testing. And then, of course, we've got over 18,000 court cases that we have to take into account when it comes to all of these issues. So for those of you that are in any of these 22 states, please remember, drug testing can only be conducted in compliance with these states' rules. Okay? 22 states. If you're in any one of those colored states, there are rules you need to be aware of. So if you're not, please make sure you get in touch with us so we can help you out. Okay. Talk a lot about marijuana. Everybody's worried about marijuana and CBD issues right now. To me, that's just the shiny object in the room. I think that the big boogeyman in the room is that issue sitting over there in the corner, which has to do with the opioid crisis. And we don't have time to get into it all, but please understand that employers are losing lots and lots and lots of money, millions of dollars these days, for non-compliance with state disability discrimination laws related to people taking prescribed medications. Under the ADA, under state disability laws, you are limited in two respects: the drugs you test for and requiring all workers to report medicines they're taking. Please understand you are better off limiting your rules of reporting and the drugs you're testing for to safety-sensitive jobs, which again points out that we need to have very clear job descriptions. Okay, so all of this stuff makes you kind of stop and think, doesn't it? And I'm going to turn it back over to Nick because I'm tired of talking.
Thanks. Thanks, Bill. Covered a ton of great information up there. Obviously, we're limited in our hour to talk about all these issues. We can certainly dive deeper into some of this stuff. But again, a lot of information for everybody to consider within their workplace screening program. So now we'll cover for you the top takeaways from today's presentation and some essentially some homework for you guys to start checking off your list, make sure that you are in the best position that you can to remain compliant with this web of compliance. These, first and foremost, is to clearly understand the drug and alcohol screening laws and the related court rulings that apply to each state that your company operates in. Bill has harped on this before, but the rules vary greatly in each of the states, and then the court decisions, or those in those states where the court has ruled or interpreted the law, that information is incredibly important as well, as it impacts your program in each of those states that you operate in. We've always stressed this, and it's always been kind of a him or ha type thing, but we highly encourage everybody to make sure they create, implement, and keep up to date a comprehensive drug-free workplace policy, a policy that clearly defines your stance on any prohibited drug and alcohol use and what the related consequences that will be imposed for those that violate such policy. Draft and implement comprehensive procedures that complement the language within your company policy. It's one thing to have words on a piece of paper that tells them what they can't do. Having specific procedures defined and how the enforcement of those rules will be conducted is incredibly important, and it will also remove any guessing or potential mistakes in one of those heat of the moment type situations where your management staff needs to act. Bill touched on this a couple times before, and I led the conversation by saying this is something that's going to be more important than ever before for employers. But make sure you have documented and routinely review your company's different job descriptions, specifically defining which ones are considered safety or security sensitive. As we see the trend in these laws and court decisions and the language of these laws being rolled out, the majority of those have some kind of exceptions to the law for those employees that are either safety or security sensitive. However, it'll be up to you as the employer to defend what safety and security sensitive means and why that position was justified as safety or security sensitive if you end up in one of those situations where you needed to justify or defend your actions. We also recommend that you educate your employees on the dangers and impacts of drug and alcohol use. Encourage your employees to seek help with any drug or alcohol addiction issue, hopefully through your company's provided employee assistant program or referral to a substance abuse professional, or some avenue to go and seek help for those that self-admit or come to you with a drug or alcohol abuse issue. And again, another very, very important component of any comprehensive drug-free workplace program is to make sure you've trained your managers and supervisors on the details of your company's drug-free workplace policy. Essentially, those are your gatekeepers for enforcing the rules that you've imposed on all your employees, so they better make sure what those rules are. Help them understand the laws that apply in each of the different states, and train them, as Bill mentioned earlier, on how to recognize the signs and symptoms of impairment of drug or alcohol use, and clearly define the action steps they should take in these instances. This is something that likely doesn't happen very often in the workplace, where managers may be shy to act on their intuition because there's not any set structure in which they should abide by in these situations. But again, it's becoming ever more important since there is the lack of a way to actually prove someone is impaired specifically for marijuana. But to be able for your supervisors and managers to recognize those signs, to act appropriately during those situations by removing the employee, interviewing them, conducting the reasonable suspicion drug test if that's a part of your program, and to most importantly document all of the details in which the circumstances led up to that test. Incredibly important these days, and will certainly save cover you when if any kind of litigation or any kind of challenge comes up in the end. And also, as it was mentioned, make sure you stay up to date with the rules, regulations, and court decisions that may impact your workplace program. This information is changing at a record pace, faster than it ever has been before for employers. So having a resource such as DSCI or even through 210 and through other HR leadership compliance forums, definitely empower yourself to make sure you have all the latest and up-to-date information as these rules and regulations change. All right, so that concludes today's presentation. I know we covered a lot, and we got some questions that came in throughout the conversation, but I'll open up the floor now for questions. As a reminder for everybody, feel free to submit your question if you haven't done so already, right in the Zoom chat feature. For those questions that we are not able to address during today's live presentation, we'll make sure we will follow up with you in the days following. Also a reminder to please visit www.askbilljudge.com. We welcome you to sign up for our industry compliance alerts that'll keep you up to date again on any changes that may happen from a statutory or court decision on the legal landscape of workplace drug and alcohol screening compliance. We also welcome you to follow DSCI on LinkedIn and Twitter for more latest news and industry updates. As a reminder, today's event did qualify for 1 professional development credit for your SHRM recertification. Please take note of the code there on the screen. And again, as a reminder, all attendees will receive a copy of today's presentation slides. So we'll go ahead and open it up for questions. And Bill, there was a little bit of confusion on the new law coming out in Illinois. Of course, Illinois now permitting the personal use of marijuana effective 2020. Can you clarify why there was some confusion initially for employers on whether this impacted employers' ability to screen for marijuana use?
Yeah, first of all, the law very specifically states that employers can have a zero tolerance policy. Employers can have a policy and discipline anybody who violates that policy, including drug testing. Where the confusion comes in has to do with, as I said, a section that was added in negotiation at the end of the rule, at the end of the law. It's called section 900-50. And what 900-50 basically says is that employers cannot discriminate for off-premises, off-duty use of lawful products, okay? But, and by the way, this is the Right to Privacy in the Workplace Act. However, the second paragraph, second section of that law, and the second sentence says, and I can read it to you, this section does not apply to the use of those lawful products which impair an employee's ability to perform the employee's assigned duties. Okay, what does that mean? Well, back when this law was written, it was written to address alcohol. No one at that time anticipated marijuana would be legal. But Certainly, we could argue that marijuana fits within that sentence along with alcohol. So it's unknown right now, but that's what's causing the confusion, because on the one hand, employers have the right to test for drugs, including marijuana, have a drug test policy, have a zero tolerance program. And on the other hand, it says you can't discriminate for off-duty use of lawful product. So therein lies the confusion. There's an attempt to essentially clarify that in the Illinois veto session this fall.
Yeah. And if I remember, Bill, you got on the horn right when the law came out, and we're ringing all the lawmakers and lobbyists trying to figure out what their intent was here. So hopefully we've raised it to their attention that there was some confusion, and hopefully they get an opportunity to quickly clarify that further.
I talked with the lead sponsor of the bill, and they just were surprised at the reaction that was occurring and the confusion. So. Yep.
All right. Thank you very much. There was another question about, you talked about the states where you do not have to accommodate medical marijuana use at work. Are there any states where an employer has to accommodate medical marijuana at work?
No.
Easy enough. So essentially,
I don't know of any state that requires an employer to accommodate use. The accommodation issue has to do with the underlying medical condition for which a person was recommended to use marijuana, not marijuana use, no.
And whether or not that positive drug test alone will be considered as under the influence, because of the fact that THC, as most know, is a fat-soluble drug, and it stays in the body for several days, several weeks, and even months after use. So it's not something that you can detect right away, or potentially can detect for weeks after last use.
Correct.
Yeah. Okay, and another question came in here. It says, so CBD doesn't make you high. I thought that it does. Why are people using CBD? So really, I'll cover this one. And CBD is, you may, it's often referred in the popular media and marketing materials as non-psychoactive, like that of THC. But that's a little bit of a misnomer, because CBD is more or less non-intoxicating, will not get you high like that of THC, the psychoactive component of marijuana. But it still does cross the blood-brain barrier and have some pronounced pharmacological effects, kind of like a body high, or impacts on things like anxiety, addiction, and other mental illnesses like schizophrenia and depression. Now, so they may be, a lot of people are using this for pain relief, as an alternative to opioids or whatever else the case might be, whatever their personal reason they're trying to use it for. So I guess really the big point to drive home here is that in workplace drug and alcohol testing, your drug screening panels most commonly do not screen for cannabidiol. They only screen for tetrahydrocannabinol, which is THC. Now, also, so I guess in that case, CBD use in of its own should not cause a positive for THC. However, as Bill mentioned, since this industry is very largely unregulated, it's the complete Wild West right now on what ingredients or what levels of ingredients are in these products, that a CBD product could certainly contain high amounts of THC, or those that are consuming a lot of CBD with small amounts of THC obviously could eventually build up enough metabolites to test positive for THC. So as long as Bill mentioned earlier, as long as they're following state laws in the states that allow the medical use of cannabidiol, or have other legal forms for you to purchase this product in places other than your local smoke shop or on the internet, or whatever else the case might be, there's a legal avenue to do so. But it certainly is buyer beware, especially if such use could potentially jeopardize your employment.
Yeah, and let me mention something there real quick, because I know we're out of time. We often get calls from employers and administrators of programs saying, well, what should we do if somebody raises the question that they're protected because of being using CBD or a medical marijuana patient. Well, a couple of things to start with. First of all, know what the state's rules are. Secondly, require the employee to get you a copy of their state authorized medical or CBD use card. And thirdly, get a copy of the letter from the physician recommending to the state that they should be allowed to use CBD or medical marijuana. Those three things should be produced by the employee just as if they were producing a prescription, a legitimate prescription for an opioid that they were using.
Yep, agreed. A little extra effort, but there's ability for them to prove such use. Okay, that is it. Our time is up. Again, I appreciate everybody joining us today. Please feel free to visit us on social media or direct on our website if you have any further questions. We'd be happy to help. Thank you again. Enjoy the rest of your week.